Hi, I'm attorney Gregory Dell here with attorney Stephen Jessup, and we're going to talk about how to file a long-term disability insurance appeal. Now, Stephen, we're going to kind of give the guide to it because there's so many factors that affect submitting a phenomenal appeal. And the biggest thing is that we don't know the definition of disability, which is different in every single policy. We don't know the occupation as we're doing this video because for every occupation we have specific things that we do. And most importantly, the medical conditions, there's hundreds of them that could be disabling, and there's all kinds of different things we do for that. But we can talk generally about the things that will apply to everybody and make the person who's watching this video be aware of what they should expect, some things that they can look for. And the other thing, obviously, is that if you're in a position where you unfortunately need to file an appeal, you should know that we offer a free initial consultation. The only thing we need is to receive a copy of your denial letter. We'll get on the phone with you right away, and we'll let you know our thoughts on whether or not we think you have a claim that can be won. And of course, right away, we'll let you know about what our fee structure is and the pros and cons of handling it on your own and why it's important to have a lawyer. So, Steve, when a client calls you, they've hired you, you're going to do their appeal, what's the first thing that you have to do?
First thing is you got to get a copy of the claim file from the insurance company. That's going to be everything that to that point from the start of your claim up into that denial that you've either submitted to them or that they've created as part of their review. So the first thing is a letter of representation out to your insurance company advising them we're handling your claim, they're not to contact you, all correspondence and communication comes to us, and requesting a complete copy of your file, because that's going to give you a really inside look as to what exactly the insurance company was thinking and their strategy in denying your claim. So that's the first thing that we get out the door. At that same time, too, we're usually starting to collect the medical records for the client, so we can make sure we're getting a jump start on that. But from a standpoint of interaction with the insurance company, most importantly, it's getting that claim file as soon as possible because they do have up to 30 days under the law to provide that to us.
Now, Stephen, when someone gets a denial letter, they kind of put like a little line in there and says you can request documentation from us. However, you can just go ahead and request an appeal, and it's very generic. The law requires on an appeal, which is governed by ERISA, which is the Employee Retirement Income Security Act, for a new person at the disability company to review the claim. The law also requires that person that they have to file an appeal, which we didn't mention earlier. You can't just go ahead and sue the disability company. Why is it so important to submit, though, a super strong appeal?
Because in most cases, you only get one shot at it. It's a one and done proposition, and that's always very frustrating, especially when we get a call and someone's appeal has been denied, and we ask to see a copy of the appeal, and it's sometimes a one-page handwritten letter saying, I disagree with your decision, I want you to, this is my appeal of my claim, pay me my benefits. And that's a horrible thing. I think the insurance companies, like you said in these letters, or you can just appeal, they don't really let people know the gravity of the appeal itself. So your appeal, this administrative appeal process, is a requirement prior to filing a lawsuit. If this appeal is denied and you have to file a lawsuit, as of the date of that denial, your claim file is closed, meaning no new information can come into it that a judge is going to be able to consider. So if you just write, a one-page appeal, you don't send any new additional information, and the insurance company upholds the denial of what they did at the claims level, you now are precluded from bringing in any information that may have supported your claim. And it's unfortunate because we'll see where people have, pretty severe medical conditions. And if there's a denial of that appeal, I'm always thinking, well, if this had been done, if that had been done, we may not even be here. So making sure your appeal has as much information in it as possible at this point is the most crucial aspect of your claim. Failure to do that really sets you up for long-term failure. The likelihood of the claim being reinstated is slim at best, and the chances and likelihood of prevailing in court are even more minimal than that. So your appeal, if they've denied your claim, nothing is more important for your disability benefit and claim than this appeal.
Okay, so I wanted people to know you don't just say, I want to appeal and have someone else look at it, because you have 1 in a 10,000 shot for another person at that same company, because you have to go back to the same company to independently review it and say, okay, the other person was wrong, I'm going to reverse it. So the appeals that we put in are 25 to 40 pages on average and have hundreds, if not thousands of pages of additional medical support and things, tons of things. I want to go through the different types of items that we include in our appeal to help prove the claim. So let's go through each of them, because we want to give some people some guidance as to what they're going to have to prepare should they try to do this on their own.
So I think basically, since this has to be relatively generic, because like you said, there are so many medical conditions out there, generally in the most generic sense, you kind of split them between two: physical or mental, emotional, mental health claims. So knowing, and sometimes it's both, but trying to figure out what type of claim you have. And that's important because you can generalize the type of claim, because the insurance company is going to review your claim based on those generalizations anyway. So you always want to think, in my opinion, starting at the lowest common denominator that an insurance company is going to. So, say if your claim is for chronic pain and you're saying you can't physically do the work, well, what's maybe missing in your file that's proving that? That could be having formalized testing done, like a functional capacity evaluation. I think it's very important to have, customized attending physician statements for your doctors to complete that really get into the nuts and bolts of your medical condition compared to your occupational requirements, because the claim forms that the insurance company are going to send are very generic and a one-size-fits-all type thing. And a lot of times doesn't give a doctor the ability to really express an opinion. So from a physical side, we're looking at what can we bolster to draw this nexus between how your pain is preventing you from doing your occupational duties. And on the flip side, with regards to mental health situations, these are challenged quite often because they're always going to argue what's subjective in nature. There's no way to necessarily verify this. So again, you and I years ago created a very, very detailed questionnaire for behavioral health specialists to respond to. And if there's severe cognitive problems, do we look at neuropsychological testing? So it's starting in a framework of the generalization of a medical condition, starting and building a big base of what we may want to look into, and then really carving it into focused information that we're going to want from your doctor. So that's how I like to start when I'm assessing what is the brunt of the information we're going to need, medically speaking, to prove this point that disability equals the diagnosis equals disability under your policy.
Right. I don't know if people realized when you were talking about the forms are wholly inadequate, because initially when people filed a claim, or for years they were on claim, they put in these attending physician statements. Mm-hmm. And what we do is we design our own statements that are very specific to your occupational duties, your medical condition, and the policy language. And the biggest advantage someone has is when they have a lawyer representing them is that it's very hard as a patient to go into the doctor. Doctors, you can go in and often say, can you write a letter supporting my claim? And they basically rewrite kind of what they've written already. This person shouldn't work. Mm-hmm. They've been my patient for 3 or 4 years and they can't go to work. And that doesn't mean, that's not going to cut it. That's just not enough. And so
if it was enough, they wouldn't have been denied,
Obviously. So the doctors need, and the doctors also have limited time. They're getting chewed up by insurance companies who are paying them a fraction of what they used to get in reimbursements. And they want to basically be given information before them that takes the documentation from their medical records, what the patient's been telling them, and lays it out for them. And that's basically what we do with our custom attending physician statements. We provide a form that's very detailed, often 3 or 4 or 5 pages. We explain to them what's going on with the claim. We also document for them what the internal doctor has said. Because, Stephen, you know that they hire these medical experts to review the file. And when these medical experts review the file, they basically give an opinion as to what's going on. So when we do our custom attending physician statements, We submit, here's what the other doctor did. We give the doctors everything and let them, so that it's not just like when they have their doctor who does a cursory review, the doctor's prepared. And that's very hard for a claimant to present that to the doctor. But I would say in all of my appeals, whether it's 1, 2, 3, or 4 doctors, that custom attending physician statement is like the end all be all. It's one of the single most important things. It's what we argue to the judge later on to say, look, what more could we have possibly given? Here's all the information. So,
yeah, and one other big thing on that as well, since a lot of times doctors too, like you said, they're busy, and sometimes they don't want to get involved with an insurance company. And under these employer-provided group disability policies governed by ERISA, I let these doctors know that, hey, in completing this, you don't need to worry about, you're never going to be called to give testimony in court. You're never going to be subject to deposition. It's not going to cut into your practice. And if this ends up in court, the only thing a judge would be able to consider are your medical records and your written opinions. And sometimes that also helps kind of ease like some of the concern of the doctors, because then they're like, all right, well, I'm not going to get pulled out of my practice. I'm not going to be, having to deal with the defense attorney crawling down my throat, trying to question my medical opinion and what I've done to this point. So making the doctors know that, hey, I need your written support. That's the end really of where it's going to be out of your day-to-day practice. And here is a way in these forms that I've kind of streamlined, has made it as easy for you to be able to, go through this information and really be able to make a fair assessment.
And the other thing is there are other tests out there. There's functional capacity exams, neuropsych exams. There may be other objective testing that the claimant hasn't undergone that we'll recommend, because we're not doctors, but from having seen every disabling medical condition and all of the evidence that's required to prove it, we basically know every test available that's out there that the disability carrier will give credibility to and will help prove the claim. So we talked about the medical, and that's obviously essential in a claim. But the other thing you touched on is the fact that we have to present strong occupational information, because 99 out of 100 times, the disability carrier minimizes the occupational duties of the claimant to some occupational class, whether it's sedentary, light duty, or medium. And it doesn't portray what the claimant did. And I know myself, I have submitted hundreds of pages of occupational information, depending upon what's going on, published articles, examples of what a person does, to show what the occupational duties are, because like we said, this is our chance to build our record. We're not going to have an opportunity later, and we can't assume, and the judge can't assume what this person did or what their occupation was in the national economy. But the other thing we do, besides all of the stuff that we take hours and hours to present, is working with vocational experts. Can you explain why you do that and how it's helpful in many of your claims?
Yeah, well, vocational experts are very important because, like you said, this national economy standard, they're going to go to the lowest common denominator of what a job is, and that's generally the physical demand level. And since, anyone who's watching this could have any type of job, just to make it easy, for instance, us as attorneys, the Department of Labor qualifies our job as sedentary. So an insurance company would say, well, we think you can work at a sedentary level so you can practice law. And like I tell people all the time, in the same situation, if the extent of my occupational demands are being a warm body in a chair for up to 8 hours while lifting up to 10 pounds, life would be really easy. But that's not what jobs are. That's not what the duties are. So while the insurance company is trying to strip it down to the lowest common denominator, you want to explore what material and substantial duties are, those duties that are actually resulting in the pay that you are receiving. So the vocational experts we do, not only are they also making an assessment based on the medicals that we give them, so they have an idea of what's going on medically speaking, occupationally speaking, whether it be your own occupation or this idea of any occupation, transferable skills. And what they're doing is they're really breaking into it in a much more thorough way than what we see from the insurance companies, because the insurance company a lot of times will cut and paste the Dictionary of Occupational Titles job description, and that's the extent of the review they do. Here they're really getting into the fine duties, these idea of what are these material and substantial duties and how, based on the medical information, you wouldn't be able to do it. And even more so importantly too, making sure that these jobs that, especially in any occupation situation that the insurance company says you can do these exist even in your market? Do they exist at a pay rate that may be required under a policy? So this goes into this idea, like we've always said, insurance companies generally speaking aren't going to challenge your diagnosis. They will normally say, yes, you have this condition, but we don't think it disables you, or diagnosis doesn't equal disability. So you're building up that nexus first with the medical, showing where those restrictions are, but the occupational review is what really kind of rounds out that here's the diagnosis, here are the restrictions and limitations. This is how it's resulting in disability, i.e. you can't perform the material and substantial duties of your job, or if the case may be, of any occupation.
So when we sit down to write an appeal, at least for me, it's like sitting down to say, I want to build a custom home. How many bedrooms do you want, bathrooms, entertainment, living room, dining room, whatever it may be. And then it's like, I got to sketch it out and do all that stuff. And everyone is different. No, not every house is exactly, the same in the layout and the view and all of that. When we sit down and do our appeal in the same manner, we're thinking about 5,000 different things, all of the facts that were there for that medical condition, all of the cases that we've seen before. How is the claim rep from this particular company going to be required to review this? How is the doctor that they're going to hire? What type of doctor are they going to hire? What do we have to have in here that doctor can't possibly rebut? What additional medical research are we going to include that doctor can't dispute, that's just the way it is, and stick it in their face so that they have to address that? But along those lines, we've now talked about, we've built up our medical support. We've built up our occupational support. And the other thing that a person who doesn't do this day in, day out like we do is, what did they do in the claims handling process? What information was in there where they made a mistake in how they reviewed something? And how do you hold that against them, that when you present it to the next level person to say, basically, look how ridiculous this review was. Meaning, take this person who's supposed to be independent at the company and make them see in a way that it wasn't even a fair review, that they missed all of this information that should have been reviewed, and they continued that theme through, and it was completely wrong. So not that we have to prove that the underlying person was unreasonable, but we want this other human being who's supposed to be independent to say, they just, in a nice way, they just didn't have this or that, and therefore here we are in our appeal clarifying for you and giving you even more all of these things. Because at the end of the day, it is a human being, at the company there who is looking at it and has to have a rationale to say why he or she either agrees or disagrees potentially with the people beforehand. So, Stephen, the last thing is that the medical reviews that are done by the insurance company those are never going to be independent reviews. But do you find that the disability company is always going to give weight to those, or will they tend to lean towards the information submitted by a person on appeal?
Personally speaking, they're going to give more weight to their own reviews. That's just the nature of the beast. And that's going to be what those reviews are. If those reviews are agreeing with what we've submitted in the appeal, claim's going to get approved. I can tell people that, since ERISA had some updates to regulations when it comes to appeals, now if you've already submitted your appeal and you get a letter, and for some carriers it looks like they're upholding the denial, but it's not truly a denial, they're giving you the reports of their doctors and saying, hey, here's what our doctor said. You now have an opportunity to respond to this if you want to. In the past, that didn't happen. So if you've already submitted an appeal and an insurance company is reaching out to you with their doctor's reports, my opinion is, generally speaking, they've made up their mind that they're going to deny based on those doctor's reports, though I have been successful in getting approvals by responding to those. But they're generally going to lean on what their doctor's opinions are. So if you don't submit strong enough information, those doctors' opinions are that you'd have the ability to work. The insurance company is going to piggyback that. But in preparing the appeal and submitting it, if those doctors are really kind of forced in a corner in the sense that, well, yeah, all this information here, I would have to agree this person is not able, to work, insurance company is going to rely on those opinions. Now, we've seen times in the past where there's conflicting, so they try to get a third person internally. But generally speaking, if your claim's strong enough, your appeal's strong enough that the reviewing doctors on appeal agree, the insurance company is going to rely on this. So at the end of the day, they're going to rely on what those doctors say, negative or positive.
Right. And the other thing is, when you write this appeal, you can't tell them every single thing they did wrong and what they should do, because if you do that and they take your advice for everything you tell them to do, then if they deny your appeal and you have to prove that they acted unreasonably at the next level, you're going to have a very hard time, unless they ignore all of the things you told them they need to do, which, yes, they are that dumb, some of them.
But does happen.
I would not take the risk and write, you need to do A, B, C, and D in order to do a reasonable review, because anyone with common sense is going to say, okay, we'll follow your guide as to what you told us to do to be reasonable, and we still don't think you're disabled. And we see those all the time. A lot of lawyers out there write their appeals like that, which is horrible. They also stuff their appeals with a ton of case law, which has absolutely nothing to do with this. But there's very little that can be done if you go to litigate. So you have to balance. Yes, you want to win, and you smother them with occupational and medical information. But at the same time, you got to think, there's a chance they're going to deny me still, and I have to leave argument room to be able to win. And that's the art of of writing these appeals.
It's presenting your medical and vocational, all that information in a way where you want the claim, the appeal, to stand on that information. But the way we present it is basically arguing case law without arguing case law. We're setting them up to, hopefully, if they deny, make mistakes that we've seen in other cases and that have been litigated. So we're not adding and letting them know, hey, this court said that or this is that. There's an art of setting them up, providing the information, and if they're going to try to screw you over, you set them up unbeknownst to them to give you good legal grounds to stand on, that when you get in court, you increase your odds and chances of success with the judge. And even also, the stronger your appeal is, if they deny it and you file a lawsuit, they're hiring outside counsel to take a look at everything. Outside counsel and in-house counsel for your insurance company have never seen this. So the stronger your appeal is, the more risk there is to the insurance company in trial, in court, and that's also going to have a positive effect on any settlement negotiations they want to make. So, you really want to stand hard and firm on all of your supportive information in the appeal.
Right. Well, I hope that people have found these tips about how to file a disability insurance appeal helpful. We certainly encourage you to contact us with a copy of your denial letter so that we can review it for you and let you know. Again, search our website for your specific company. We've done tons of videos specific to your company. I guarantee that you can find, and it gets into a little bit more detail about the nuances of your company. I always say the more you're educated about this process, the better your chances that you're going to get approved for benefits. And the goal is to maximize your benefits, and we'd like to help you and lead you through that process so that you can get your benefits. So call Stephen, call myself, or any of our lawyers. We'll be here when you need us. We help you anywhere in the country, and we appreciate the opportunity to speak with you in the future.